So, hello everyone. It's 8 in the morning in Washington, and I'm very glad to see you guys. I will speak English, but anytime I can switch to Russian. Я всегда могу переключиться на русский и объяснить и спросить. Пожалуйста, спрашивайте. Для меня это очень важно, чтобы у нас была интерактивная сессия. Please ask in chat, in a person, turn on your microphone and ask me questions, because my goal is to really answer what you need, not just to share what I know. Okay, so today we will talk about typical misunderstanding between us, US attorneys, patent attorneys, and other world, I would say. So some kind of specifics of US patent office. And here I use the word specifics, which is again very US oriented word. When you see the word особенности патентного офиса, like everyone who studied in Russia will say peculiarities of patent office. And peculiarities is English, British word. We do not use it. We use specifics of US patent office. That needs to be taken into account. A few words how I came to this situation and position. I am graduated from physics department of St. Petersburg University, and I was and made PhD, my thesis in laser physics. And in 2001, I was invited to work in the United States, where it turned out that the best thing I can do is to write patents and to invent and to do all kinds of patent work. And here I am, licensed patent practitioner of United States Patent Office and a president of the company called Patent Hatchery. Patent Hatchery – это патентный инкубатор. Our clients are, many of them are Russian speaking inventors or attorneys from 50 or 60 countries of the world. So Russians are everywhere. And we're glad to work with you, and we're happy to serve whatever you need. Here you see on this slide at the bottom is our website, US, like United States, -patent.ru. So go there and you can find our contact information and ask questions out after the it looks like you also turned off my ability to change slides, Shane.
Just a second, I will try to. Can you change the?
We checked it before the lecture and it worked, but now it does not.
Okay, just a second once again.
So the first thing that I want to talk about is called transparency of all patent system, which is unusual. Very. So in United States, you can see, I still cannot change slide. In United States, you can see all documents that are submitted related to your patent application. It doesn't happen immediately. It happens after 18 months from the priority date. So after 18 months of, for example, you filed a Russian application, and in 12 months you submitted it in the United States, and in half year after that, it will be published, and at that point you can see every document that goes in and out in your patent application.
Nadezhda, is it better now? Because I've changed it to my presentation. If it can. Okay, it's better.
Thank you, Jenny. So that's what we call transparency of all documentation. So the website that is responsible for that, it's called public PAIR, Patent Application Information Retrieval. PAIR is patent. So this here, it's very explanatory. So you type public PAIR and you go there, it asks application number. So you type your application number and you see here the list of all documents that are in the file of your patent application. Whatever we submitted as patent attorneys, whatever US examiner responded, everything there. So in fact, you can check what's going on with your patent application every moment. Again, after 18 months from priority date. And almost nobody knows about that. And so there is no point to ask us, what is the status of my application? You can go there, you can see what is the status. So we are waiting for another office action, or we need to respond. So typically for response, in United States Patent Office, we are given 3 months without fine. Fine is это штраф, да? Without fine, you can file within 3 months, but there is no reason to wait for these 90 days. You can file response anytime. So after 3 months, for the first month extra, you pay $110. For the second month, it's $320. And for the third month, it's $740. So the longer you wait with your response, the more expensive it is for you. So do not wait, respond within these 3 months. Now a few words about patent applications that we receive and what typical corrections we need to make in order to comply with US regulations. First of all, abstract, referat. Referat, and we are talking at the moment about utility patent. Utility patent is патент на изобретение. Utility patent. So, and utility patent can be on device, on method, on composition, for example, like pharmaceutical composition, or, any kind of, printing buildings or things like that. Another type of patent applications and patents is design patent applications, and we will talk about them later. So now about utility patents. So патенты на изобретение. You know that at the beginning of each utility patent, you have abstract, referat. And this abstract needs to be less than 150 words. And since many of you go through PCT application, PCT is international application that is valid in 152 countries. So typical way of protecting your intellectual property is file in your country, national application, Russian. Then file PCT application for 152 countries, which never ever becomes a patent. PCT application will never be a patent. And after 30 months from this PCT application, you file national application in the countries that you are interested in. So for example, United States, Europe, Canada, whatever other countries you are in, China. That's what I'm listening. I'm telling about typical countries that people are interested in. Why do we need to file in different countries? Because patent is a national thing, national. So if you file a patent in Russia, it is not valid in United States. If you file a patent in United States, it's not valid in Russia. So, for example, if you like something that you found in United States patent and you like it dearly, and you want to produce this thing in China and sell it in Russia and Germany and other countries, not in United States, you are welcome to do so. You can do that. It's totally legal to take other countries' patent and produce it in your, produce this kind of product in your country. So once again, we submit typically patent in one country, in your country, then PCT application to 152 countries, and then you choose in what country to submit it. For example, you submitted it in the United States and Europe. So when we submit this national US application based on PCT application, we have to translate exactly what is in PCT application. So if you put in your abstract more than 150 words, we first need to file as it is with all whatever 200 words, and then we file petition to change abstract to 150 words. Of course, you do not need this additional work and additional procedure, so just keep it below 150 words always. Oops. Claims. Claims is a heart of patent. Claims – это формула изобретения. I have seen translation of so many versions how you translate формула изобретения. It was clause, it was point, it is claims. To claim – это заявлять, да? Claims. Итак, so claims is actually what belongs to you. The description of the patent is just description. It's like a paper, like an article, scientific. What belongs to you is a claim or claims. And traditionally, I think it comes from Soviet Union. The way the claims are formulated in Russia is very different from United States, Europe, and other countries. And this is the most important thing of today's lecture. Claims must give you certain niche in market, in business, in market. You want to occupy as much place in the market as possible. In Russia, claims, формула изобретения covers exactly the device that you produce or you patent. It's a device that consists of sometimes dozens of details. Look at an example of this claim from Russian patent application. So its claim, one claim is 2 pages. So the more elements you put in the claim, the more narrow is your protection. And this is almost have no sense to have the claim like that and to have a patent like that. Because when you take out a little piece of this claim, you now not infringe this patent. Я, пожалуй, скажу еще раз по-русски, чтобы уже все было понятно. Когда написано очень много в формуле изобретения в одном пункте, это очень узкий пункт. И если сделать устройство, в котором не будет хотя бы одной маленькой части из этой формулы, уже это не будет нарушением этого патента. Таким образом, вообще вот такой патент, он имеет очень мало смысла, потому что он не защищает потребителя, авторов. So, I'm continuing in English. So, when you pay standard fee in United States, which is around 300 something for examination, you actually pay for 20 claims, out of which 3 are independent. Independent means one of them is for device, another one is for method, and the third one is for the system that includes this device. So for example, you have a transmitter and you have a system that uses this transmitter. So these are independent claims that up to 3, and the rest 17 out of 20 are dependent. If you want more than 20 claims, then you pay extra. For each additional claim, it's $50. If you need it, of course, you pay more fee. This is the most important part. What, you know, Zinger sewing machine, да? Швейная машинка Зингера. What he patented is a needle with a hole at the bottom. So иголка с дырочкой внизу. So he said that any machine, any device that has a needle with a hole at the bottom is mine. So he took the whole market of sewing machines, whole, everything. He said, it doesn't matter what kind of device on top to this needle with a hole at the bottom. It's all mine. So that's how a business is made. So you find little thing, little innovative thing, and say that everything what has it is yours. So this is how claims need to be formulated. And this is knowledge and art of patent attorney who works with you and who can formulate these claims properly to make it for you to protect, really protect what you want. Look at the typical structure of US patent. On the first claim, it's, for example, a video conferencing equipment comprising of microphone, generating audio stream, and audio encoder и кодировка этого аудиосигнала. Microphone and encoder coupled to microphone. Claim 2 is dependent claims. It depends on claim 1, means that it includes everything from claim 1 and something else. So the appliance of claim 1, further comprising a video camera for generating a local audio video stream. So we add video. It was audio, now we add video. Okay. The third claim, actually, it's appliance of claim 2. And claim 2 is microphone, encoder, and video camera. And now we add video encoder to video camera of claim 2. So it includes everything from claim 1, claim 2, and adds something additional. So this is an approach that we take. For example, examiner, expert, examinator патентного офиса, examiner finds prior art, finds some other invention that has microphone and audio encoder. And he said, no, claim 1 does not work because we have already, it is already invented. So then he looks at claim 2, and now he has to find audio encoder, microphone, and camera. And if he cannot find this version, then claim 2 is allowed. So what we do, we just add video camera to claim 1 and issue patent. If he finds also video camera, then it's the next step. We want him to find, examiner to find microphone, audio encoder, video camera, and video encoder. So that's how we narrow and narrow and narrow our invention at a certain point when examiner will say, okay, we don't have like that. So this is the level that when the invention will be allowed. That's how claim structure is created, and that's how you find what is not invented by others, right? You try step-by-step approach to find what is really novel. Translation. This is, это песня, конечно. Translation is, needs to be done by a person who knows patent law. Otherwise, you will really get stuck with not understanding by examiner and our corrections. Look at my corrections just of English. How many red spots you have? And I had to do that because if I will submit translation as people send us, there will be mistakes pointed out by the examiner on each of that. Each of them will be corrected by the examiner, each red thing. It will be a list of mistakes listed by the examiner. And I will look extremely stupid as an attorney who submitted such, okay, we learn English, okay? So such a shitty job. Okay, so one of the rules, if some element is a first time in the claim, we have article A. It's indefinite one. And if we have it second time, the same element, for example, combiner. Okay, first time we say the device having a combiner, comma, запятая. The combiner having a wheel. So first time combiner with a, second time with the. It means that it is the same combiner that was the first time. If you have not just one combiner, but 2 or 3, we never say we have a combiner and another combiner. И другой. No, never. It must be a first combiner and a second combiner, where the first have that and the second combiner has that. So you always have clearly point out which combiner by adding first, second, and other definitions.
Nadezhda, can I switch to another slide, or should I stay here because we have this next paragraph with again red spots here?
What?
Is this slide better for you now? Can you see? Ясность формулы изобретения. Is it better?
No, I am still on translation.
On translation, okay. And there is a question from Andrei Andreev. What is PCT? HCN, I think that was a mistake, but what is PCT? Yes, is that the question you're asking? Is that right?
PCT application is Patent Cooperation Treaty. Patent Cooperation Treaty is kind of agreement between 152 countries to submit one application and examine it. It will never become a patent. It will be just application with some kind of conclusion, is it patentable or not? But it is, then you need to submit this PCT application to different countries. And when you submit it to United States, examiner takes into account what's that examiner of PCT, but he always performs his own examination. So PCT examination important, but it is not final. Final examination is always now on national level.
Mm-hmm. Can I add something? I'm a trademark person, but if I'm correct, the PCT is international system which helps an applicant to file an application in one place, which is International Bureau of WIPO, World International Property Organization, and then WIPO sends your application to the countries which you are interested in. And if, for example, you're interested in the United States market, then USPTO gets your application and examines it. Is that right?
No, it doesn't work like that. So you submit PCT application in your country, usually. You can submit it also to WIPO in Switzerland, but you submit it, for example, from Russia in Russian Rospatent. And examiner of your country will examine it and give conclusion if it is patentable or not as a PCT application. And then based on this examination, you yourself hire attorneys, lawyers in each country where you are interested to continue. And then you pay, of course, for the work of lawyers in that countries to proceed with filing in that countries. PCT does not do this work. They only provide some kind of examination of your application. Many our clients from Russia actually work with us as one source. So they submit US applications through us, and also many other applications, say China, Canada, Australia, Europe, through us. So they really work only with us, and we work with our partners. We have partners like in 60 something countries. So, and we selected them over number of years and mistakes. So we found really firms that we can work with, say in China or in Singapore. So we know those people. So again, you have to have a representative in each country yourself. So another mistake with translation is that clients send us not the translation of the last version of PCT application. They send us translation of the Russian application, which is different from PCT, or the first submitted PCT application, so on. So what we need is translation of the last version. The next thing is, how clear is your claim? You need to keep the same word for the same element. You do not say one time splitter, another one is coupler, which is the same, which is a synonyms. You do not use synonyms ever in patent application, and especially in claims. There is no use of the word for example. There is no use and another. For example, you can use different elements like sodium, можно использовать натрий, калий и другие. This is not acceptable. You really need to list all things that needs to be used. There is no, also it is not possible to use and or. I know that it is possible in Europe and other countries. In our country, you either and or. There is no use of its. For example, see here in the first line, a method for searching in the claim. The method for searching an image of a flat object of a known shape and a known size, its projection, of course, projection of the object, but it's absolutely impossible because it can be applied to shape, to size, to object, to image, to anything. There is no word its. And then connecting word, comprising. I think there we don't have in this claim, but anyway, so in mathematics, we know there is a closed system and open system. Open system includes what is there and everything else. and this is the word comprising. So, for example, if Zinger formulates a sewing machine comprising a needle with a hole at the bottom, means that this is a sewing machine that have this needle and anything else, and all of that is mine. He says it's my property. And include is also including. So including is the same, open system, what I'm saying and anything else. This is most of the claims in the United States use these words, comprising, including. If I'm saying consisting of, this is closed system. This means this, and this, what I listed, and nothing else. For example, if you, we made such a patent application about catalyzer for some kind of chemical process, and they say we do not use water, and this differs us from anything else. So we list consisting of, and then we list what they actually use without water. So, and then this is how you protect some kind of inventions where you only need this little amount of elements and do not want anything else. Many times claims are descriptive. Descriptive means that they are not structured. Claim is, I have this connected to this, one connected to two. I have two connected to three. I have three connected to one, and all of them form my device. This is clear system of listing and logical listing of elements and how they work together. And descriptive style that we often see in patent applications from Russia is saying it's like a story. It's not a logical and structural thing. And after that, we receive, like here, see in cursive in the middle, search cannot be conducted at this time due to indefiniteness of the claim language. How embarrassing this, to get this response. So examiner said, I do not understand what you are saying. Your English is, and your logic and your formulation is so bad. I just cannot really examine this patent application. This is very embarrassing. All right, so claims is the most important part, and let's talk about other parts. What problems we have with the description, описание изобретения. So it's not detailed enough. So examiner said we cannot actually build the device. The description must be so detailed that somebody can build such an invention. Indefinite, so multiple meaning of the word. Like we use correlation for that. Мы используем корреляцию. What kind of correlation? Correlation of what with what? It's indefinite. You can interpret it in as many ways as you want. Then too narrow description. This comes from Soviet Union, as I said, where you only protected the device that you have. Actually, you need to describe multiple versions, multiple variants, how it can be used here and there. Use alternative solutions, even if they are not perfect, it's okay. Everything what is in claims must be included in drawings, each and every element, and this connection not always exists. So there are only a couple drawings and they do not reflect what is in claims. Description and drawings sometimes very different. You can describe it in description, but it is not shown in drawings, or vice versa. And English, that sometimes examiner says it is not English, it's some foreign language that I don't understand.
Nadezhda, there is a question if you can comment. Мало альтернативных решений, maybe just more details.
So alternative solutions. So you can use this device with this element, or alternatively, you can replace it with something similar, or you can replace it with something similar. Like with sewing machine, you can you actually have to describe not only just a needle with a hole at the bottom. You have to describe the whole sewing machine, and in the description, and another sewing machine, and another sewing machine, different versions, all of them will use this needle with a hole at the bottom. And you say, we really only think that our property is this needle because it can be used with all alternative sewing machines. And all of this niche is ours. These are alternative solutions for devices that can be replaced. So moving again to the presentation. So unity of invention. Unfortunately, in recent time, our examiner loved to split patent applications. They say that method can be used separately than device. And they issue so-called restriction requirement. They say, for this money that you paid for examination, I only will examine one of two inventions that you have. One of them related to method, for example, accelerating evaporation of water using solar radiation, or device for accelerating evaporation of water for this purpose. Because I need to search for prior art in different technical classes, there is actually no way to argue back. Even if you argue back and say, no, they are actually cannot be used separately. This device only can be used by this method, and this method only applicable to this device. It's actually, it will not result that examiner will change his decision. Unfortunately, in recent years, this became a practice that examiners split your invention. Then what to do? You choose either device or method for further examination. Okay, and you can submit another one as a separate patent application. So instead of one patent, you have two patents or three, whatever, how many. In one of patent applications, examiner found 36 different inventions. 36. So instead of examining 36 versions, he only wants to examine one, and you have a right to submit other 35 as separate patent application, and of course pay each time and for the examination. This slide is about continuing patent application, which again specifics of United States law. There is no such thing in other countries. That's why I wanted to show you that. So once you have a patent application submitted and it is almost allowed, it's allowed, but you did not pay issue fee yet, you can submit so-called daughter application. So for example, you say, oh, and now it was 3 years since I submitted previous patent application. Now I have this feedback loop, да? Обратную связь. Feedback loop that adjusts parameters of the device and makes it really, more efficient, 50% more efficient. And this can be filed by daughter application. So daughter application describes almost everything what was in the previous mother application and additional thing. And mother application cannot be used against daughter application. So typically, the invention in daughter application is not that inventive, not that big. You add certain thing, for example, cooling system or feedback loop or something that otherwise would not be clarified as full inventive step. But because mother application is allowed, daughter application usually allowed too, and very brief, very soon. For example, in 3 months. We have a laser company from Russia that makes this connection, daughter application, granddaughter application, granddaughter application. So they make the chain of patents, and all patents are issued in 3 months, So they have the whole bunch, up to 6 now, patents, all of them done this way. Each time they add a little bit, and make the new patent. Also, continuity patent is very good if you need to correct something. So examiner found that you've been missing describing certain things, and the patent cannot be allowed because it's really defective. There are certain things that are missing in your application. You can file daughter application by adding those things. This is the way to correct certain mistakes. And daughter application has the same priority date as mother application. So you still keep your priority and you correct it by adding certain things. As you know, you cannot, after you filed patent application, you cannot add anything. You cannot change any, you can change claims, but you cannot change description. So the only way to add something is to file daughter application. This is the way to correct Russian inventions if we need to add something. The basic rules. So patents are granted on something novel, something useful, and non-obvious. So a few words on non-obvious. It must be unexpected result, something that is unusual that makes invention. So the combination of typical two things that you are heating something and it's actually the temperature rises. It's obvious. It's not makes invention. But if you heat something and it actually cools, this is invention. Let me give an example of Russian expression. Чем больше нас, тем меньше веса. Что это? This is conflict. There are more of us, but it's less weight. Это дырки в сыре. Вот это немножко something that is unusual. That's what makes invention. Okay? Useful. Useful means полезное, да? And this becomes more important now with filing patent application for software. So software must be useful. That's how you can protect software. For example, if your software opens sofa, closes sofa, makes it like a bookshelf, this is patentable. But if your software is optimization of stochastic process of and this is not patentable, this is abstract. So this is the basic approach to patenting software. Very quickly about timelines. Do we have additional time or do we have, is it okay? Timing is okay?
Yes, we have no limitation with time.
No
so-
limitation. Okay, thank you.
Mhm.
So that the patent application in United States can be filed after first you have an idea, then you published it or you shared it with other people, and then in 12 months, within 12 months, you need to file provisional application. We will talk a little bit about it. And then in 12 months, you file non-provisional or full application. So you see, we have very flexible rules. We have practically 24 months, 2 years from the time you described it to somebody to file patent application. 2 years. This is given for you to find investors, to do some preparation work. After patent application is published, is filed, non-provisional application filing, in about 3 years, the patent will be examined and issued. There is such thing as accelerated examination, and I will tell a few words about that. But typical time frame is about 3 years for the patent to issue. In Europe, in other countries, first you need to file patent application, and then you only can publish and talk to somebody. First filing, then sharing this information. And usually in Europe, patent applications are very expensive, much more expensive than in the United States. So it is challenging first to file application and then to find investors, to talk business plans with somebody. This is a major difference between US and other countries. We can first file and discuss, and in 12 months file one application, which is provisional. Provisional application is предварительная заявка. This is something that here, provisional application, this is something that you just file. It can be your article, scientific article, or it can be even on napkin, да, что-то на салфетке. There is no formal formalities applied to provisional application. It can be anything. Your PowerPoint presentation, if you think it really describes your invention. Of course, we encourage everyone to put as much as possible. You can then throw away a part of provisional application when you will prepare and file full non-provisional application. You can throw away a part. So I would rather recommend that you put everything what you even think about. So it will have a priority date of provisional application. When we file non-provisional application in 12 months, we really do a thorough job. We prepare very structural description, claims, drawings according to rules, and so on. We can take all provisional application to non-provisional. We can take several provisionals to non-provisional. We can take from one provisional, we can make several non-provisionals. If you put a lot of material in provisional application, we can split it later in non-provisional. And the cost of provisional application in our company is like $500, including fees. So it is really not that much of expense. So you put all your ideas, you have priority date, and now you can share it with somebody. We have 8 clients in Australia, and what they are doing, they file provisional application in United States. And then in 12 months, they file PCT application in Australia. And then decide in what countries they go. But they have priority, they use these rules of United States to keep a priority date of their invention. Now, a few words about design patent applications. Well, it's often another disaster that we get. I mean, when the design patent application comes through international design application and then comes to us, we need to work with the material that was submitted on international stage. If we file directly from some client from abroad, then we can tell them that we need 7 drawings at least. So the view from the front, the view from the back, the view from the left, the view from the right, the view from the top and from the bottom, and then isometric, like this airplane. This is actually our really patent application that we did for airplane from Zhukovsky. And it came to us from international applications that inventors filed through the international system. And all drawings we needed to redo all of them. So there are certain rules that it's very long to describe. See how you can mark the curvature of elements, how you mark that some parts are glass. So all these rules need to be followed when you file. And actually, I think they're international rules. They are not specifically US. But what we got very often from international applications are not according to those rules. So please order in advance those drawings that are according to rules, even if you submit international application. Ask us how to make those drawings correctly. And other thing is, something can be missing. For example, everything here, front view, back view, only the view from the bottom is missing. And this can lead to rejection. Luckily, in this case, it was missing, but examiner took into account, we made disclaimer that the bottom view is not a part of the design, but in fact, we need all 7 of them. All 7 drawings that I listed here. And very often we have a design of something that can be folded, что-то, что складывается. If you can fold something, you need not 7 drawings, you need 14. You need first like in full size, and then also 7 in folded, все в сложенном виде, те же рисунки. And in the best scenario is also like half open. All right, so enough about design patent application. So be very careful. All drawings are black and white with lines. There is no shading, никакой заливки, ничего, ради бога. Только black and white lines. All right, so I think I convinced each and everyone that that when you plan to submit something abroad, please ask us if it comply with US and European regulations before submitting PCT application. And it's exactly 1 hour now that we had this lecture. That's wonderful. And thank you for your attention. Here is my email, and you can ask any questions. I will be happy to respond.
Nadezhda, I have a question. I think it will be first. So just to compare IP objects, we here in Russia have also полезные модели. So they do not exist in US patent.
They don't, but they do exist in Europe.
So if we wish to patent something which is kind of полезная модель, we should choose between invention or maybe it's
invention or design.
Or design, yes. what about
typically we piloted the pensions.
Mhm. What about software? You told us about approach when software controls or how to say does some new function with a regular device, but we can also protect it in the United States as a copyright, using copyright, yes. And are there any I don't know, cases with patenting software? So.
Yes, copyright, it's a good question, thank you. So software can be protected with copyright and with patents. So when you protect it with copyright, you protect software written in specific codes, in specific language, and it protects from exact copying those codes, coded. So you cannot copy the whole thing or part, even a part of the copyrighted material, you cannot copy if it is protected by copyright. With software patents, it's very, very different. Patents protect algorithm. They protect method of doing something, the sequence of actions. It is not related to any language. It's not related to routine procedures or whatever. It is related of logic behind software, how it works, how it operates. So this is a major difference. So software protected by patents are more general. It's protection of approach, how to do things. And again, patentable is what is linked to hardware, what is linked to something that you can touch, какому-то железу. То есть нужно, чтобы софт был связан с чем-то реальным, что можно потрогать.
Программно-аппаратный комплекс. Okay. And also a question from me, it's about effectiveness of protection. If we talk about patent, utility patent, so we talk about invention, what is better protected if we need to go to court to claim some infringement? Is it better, is it method or device? Which one is better protected? How do you think as an invention?
No, typically device is better, but method is also possible to protect, definitely. It's not like it's hopeless, but device is much more clear because it's certain, there are certain elements, clear elements that are hopefully described very well in the specification.
Okay, thanks. So if you have questions, please write them in the chat or turn on your sound. I'm trying to welcome all the participants.
Because one of the purposes of this workshop is to talk in English, have an ability to talk in English, and please try to talk, and of course we can understand always and switch to Russian if needed.
Okay, I'm trying to turn on
Yes.
the sound.
Okay, so thank you. Nadia, I have a question about the pre-application, as you said. It's a publication or drawing or presentation. So in Russia, we have in law that the publication, that you made a publication in some journal, you have a 6 months when you have a not priority, then you can make a patent application. After 6 months, it becomes world technical, and you cannot make a patent application for it because this is a world of knowledge, technical knowledge, and have you some law and can, if you publicate this publication in the scientific journal or the same journal and send as a pre-application. It you have ability to have this publication as priority, or after 6 months you have the same law. That's not.
We do have 12 months from publication to filing either provisional application or non-provisional application. You can file, for example, in 12 months provisional application. You can file.
Make parallel provision application and the same text you publicate in the some journal like an author law, not patent in field of patent law, but in the author law.
No, the priority will be from provisional application. So you file scientific article on January 1st. Next year, on January 1st, you file provisional application, and this will be your priority date.
And you have no time from you publicate in journal, and we after 6 months we can't use this invention. We can't patent it because it became
public knowledge. Yes, the same, but 12 months. 12
yeah,
months.
the same. 12. You have a 12.
12 months. If you miss the deadline of 12 months, it's public knowledge, so you cannot patent it.
So if you publicate in journal after 12 months, you make a provisional application, and after 12 months you have a law application.
You have
non-provisional full. You can make so.
Yeah. Yes. Yes.
So you have 24 months after public. Yes. We have only 6.
Yes.
Thank you a lot.
Okay, so I'm again putting this slide with non-US patent application so it can illustrate the situation.
Well, in different countries, everything is different. You know, in some countries, you absolutely cannot publish before patenting. And this related to many European countries. So this puts lots of restrictions on patenting, because it is expensive to patent and you don't know really what will be the response of the market, and we sometimes do not have those money. For example, the fee, пошлина, for filing European patent application is about 3,500 euro. 3,500 евро – это пошлина за подачу европейской заявки. Это только пошлина. And preparing application, typically European lawyers have hourly rate about 300 euro per hour. 300 евро в час – это получают европейские патентные юристы. То есть они не получают эти деньги, вы им эти деньги платите. So it is very expensive to prepare European application. And you need to do it before talking to anyone, before publication, before sharing this information with somebody. In the United States, it's much more easier policy than in Europe.
Okay, Nadezhda, what were the most, I don't know, interesting cases you patented? You helped your clients to patent as an invention or a design? maybe something funny or unusual?
Well, it's about our practice. It's not in general, right? So yes, our company did almost 1,000 different patent applications, both design and utility applications. I would split it into different categories. One category is inventions that originate from Soviet Union. For example, like big chemical plant that files something, or for example, some oil and gas companies. The inventions actually were done somewhere in 80s or 90s. This is one thing. Another thing is new style applications like software, like blockchain, or some applications for smartphones, mostly young people, specific of them that actually they do not study any prior art. They absolutely sure that what they invented is absolutely unique and nobody ever did it. So, my dogs. This is another type of applications with examples. There are a bunch of applications about toys that people sell on Amazon. Actually, quite a number of people selling on US Amazon their toys, like construction or these kind of things. And they are patented, they are trademarked, and then they sold on Amazon. It's interesting. I love design applications from different countries, like a helicopter or airplane or quadrocopter for bringing people, different, they're beautiful things. What is interesting that sometimes people from Russia patent, for example, the system for cooling a nuclear reactor. So one person applies for a patent in United States, a cooling nuclear reactor. So of course, patent office calls me and asks, excuse me, for what project is this patent application? Do you work with a nuclear power plant in the United States and they have certain rights? No, it's just one pensioner from Russia who wants to publish this patent, to file this patent application. Actually, another thing is, for example, inventing of bicycles. We have a number of inventions for bicycles. You know, изобретать велосипед is such a used Russian expression for things that is really known, right? Не надо изобретать велосипед. In fact, we filed a number of patent applications from Russians on inventing new types of bicycles. What are the specifics? I love this Russian invention on printing buildings. Printing buildings with a kind of equipment that has radial symmetry. So the composition comes from like crane, like a crane with this, and it prints buildings. And these inventors have a great success all over the world. They now print buildings everywhere in the United States, in Dubai, and they have project from NASA to print with this system buildings on Mars. Great. Another absolutely wonderful company from Russia, from Moscow, is on checking leakage from underground pipelines with oil. So they are able from the top, without undigging ground to check if there's a leakage in the pipeline. And they also have a variety of wonderful projects in the United States, in Dubai, in Singapore, Malaysia, Australia, Canada. So they are checking with their technology if there is a leakage в нефтепроводах, утечка нефти в нефтепроводах. Well, I can talk about my favorite clients forever. I love them, all of them, and they are wonderful.
Thank you. That's really interesting. So, any other questions? Please use chat or turn on your sound.
Oh, Marina, you want to
yes,
turn on your mute.
You need to turn on your sound. There is a button, usually somewhere on the left.
Oh yeah, now you're on.
Okay, dear Nadezhda, when you will be in St. Petersburg personally for the consultation. Can you hear me?
Yes. Great. So anytime you can see our email here, and anytime we are ready to answer.
I think the question, the answer will be when the aviation starts to fly again. Whereas we would like to meet offline. Yes, we would like to meet face to face. That would be great, but 2020, this year, so gives us some issues.
It needs
yes,
to
unfortunately.
For this. It needs to invent some maybe some medicals for this.
Yes.
Yes, it would be
Do you have some applicants with COVID fighting medicines or
Yeah.
drugs or something? Of course, we learned that a lot of patent and trademark organizations in different countries, they accelerate such applications.
Yes, yes, we have the same. We have the same. So you can accelerate if it is related to COVID. We actually submitted some kind of mask design for COVID. We didn't get it yet, but I hope it will be accelerated.
Great.
All right, thank you.